Hi, this is Mark Pizzacalla and welcome to Legalwise, what you need to know with Dr. Mark for July 2024. What I want to talk about today is entering into contracts for the sale of a business. You might say, what's so exciting about that? Well, we've got a case that just came out, federal court decision, Kilgore, and it looked at the market value of a business versus the capital proceeds that they actually received in relation to the sale of a business. And this particular case had 4 taxpayers. They sold their shares in a company for $31 million. That's about 10 times EBITDA, not bad. It was an online social platform which allowed the users to exchange horse tips and had 2 sources of income, one from advertising on the website and one from commissions from bookmakers. And look, after the sale, each of the 4 trusts brought to account as assessable income the appropriate amount, and that was all good. But some of the taxpayers indicated, look, we think that the amount that should have been brought to account was the market value, not necessarily the capital proceeds that were received. Now, why would taxpayers want to do that? Well, predominantly in relation to the small business CGT concessions, if they got the number below a certain amount in their respective tax returns, they potentially could have got the whole capital gain tax-free under the small business CGT provisions. But they had to demonstrate that market value was different to capital proceeds received. There is a rule in the capital gains tax provisions which talks about the market value substitution rule. This is where the commissioner can come in over the top and say that there's a different value. Now, the federal court looked at this and said, look, from their perspective, market value means that you're dealing with each other as unrelated parties, and they were in this case. You had the taxpayers on one side, you had News Corp, who were the buyers, on the other side. Secondly, though, you have to also be able to demonstrate that you're dealing with each other at arm's length. And again, in this particular case, the federal court said, well, look, News Corp went to a lot of trouble to value these shares, significant analysis, significant examination of the records of the company. On that basis, the federal court was satisfied that there was no collusion and that the parties were in fact dealing with each other at arm's length. So the market value substitution rule didn't apply. That's life. But what it indicated to me too was that from constructing a contract, you need to look at these things. If you're a lawyer, if you're an accountant, and you're considering the sale price, who are the parties involved? Who are the buyers and sellers? Are they known to each other? Do they have a pre-existing relationship? Was the price struck arm's length? Was the price allocation appropriate between the different assets that are being sold? Are the parties in fact dealing with each other at arm's length? So all these things become important. Bear that into account as you're entering into your next big purchase or sale. If you have any questions, by all means, give me a call. Speak soon.